the father in this case, Anthony Truelove. We're appealing from an order terminating his parental rights.
Sir, would you speak into the mic, please?
I'm sorry. We are appealing from an order terminating his parental rights. There were 3 grounds alleged. They were abandonment, failure to visit, abandonment, failure to support, and persistent conditions. The trial court found 2 of the grounds, the abandonment, failure to support, and the persistent conditions. The trial court also found that termination was in the best interest of the child and granted termination. So that's what we're appealing from.
Counsel, let me ask, is the mother, is her appeal here too?
It should
Ashley.
be, right?
She briefed it.
Yeah, she briefed it. That's what I was,
Not request for argument. Cover of it.
have we heard anything?
Back away from others.
Okay.
I haven't heard anything.
All right.
Argument is not she either.
All right. So the mother's is in on, for Ashley Truelove is submitted on briefs then, I guess. All right, I'm sorry. Go ahead.
Okay, no problem, Your Honor. As you can imagine, I agree with the trial court on the failure to visit ground. The trial court found that the parents had exercised more than token visitation during the relevant time period. Therefore, the trial court could not grant that ground. I do disagree with the other 2 grounds. I would like to, though, because it's so central in my argument, in my brief, the timeline, I would like to go through that briefly again. On February 12th of 2021, the petitioners filed a petition seeking custody of 2 children. They, on that day, also got an ex parte order that gave them custody. About a week later, they entered an agreed order with the parents that said the parents would have some supervised visits with the petitioners to supervise. On March 12th, 2021, the petitioners filed a motion to change the supervisors. There were 3 agreed orders entered in short term right afterwards. On March 18th, 2021, on March 26th, 2021, and then on March 30th, 2021. And what the agreed order said was that the parents could have supervised visitation up to 5 hours a week at Solomon Family Solutions, which is a company in our town that supervises visitation. Those orders also said to the parents, if you guys ever want to get more than this visitation, then you're going to need to submit clean hair follicles to the court, and you're going to need to attempt a mediation. If that's unsuccessful, then you can petition the court and ask the court to grant you more visitation. Roughly 2 weeks after the last order was entered on April 13th, 2021, the parents filed hair follicle drug screen results showing that they were clean. In June, on June 14th of 2021, the parties mediated. They were not able to come to an agreement. On July 12th, 2021, as the orders had directed them, the parents filed a motion for increased visits, unsupervised visits. And then 2 weeks later, on July 26th of 2021, the petitioners filed a termination of parental rights proceeding. On the failure to support ground, the statute provides that given when that termination was filed, the relevant time period would be from March 25th, 2021 until July 25th of 2021. And under that statute, the petitioner must prove that either the parent paid no child support whatsoever during that relevant time period, or that the child support paid by the parent was token. Same statute defines token, says it's insignificant under the circumstances of the case, insignificant given the parent's means. Now, the proof at trial was that the parents were visiting their 5 hours per week at Solomon's pretty consistently during that relevant time period. The proof was that the parents were being charged $20 an hour for visitation at Solomon's. Therefore, they were having to pay $100 a week to visit. The proof was that in the latter part of July, the parents started missing visitation, claiming that they were unable to pay. And the proof was that in November of that year, Solomon stopped all the visitation, saying the parents were too far behind in their payments. In my proposed findings and in my brief, I've made the argument that the $100 a week my client was having to pay to visit his child should be considered as child support for the purposes of this action. Now, I understand the case law, you can't modify child support retroactively. It's pretty much impossible to do so, and I'm not asking the court to do that. Quite frankly, if there ever is a child support order in this case, my client will owe whatever it is they owe. But I am asking, in this case where we're trying to terminate parental rights, that we consider that $100 a month as child support. So I went to the definition statute. I figured I'd start there. Could not find a definition for child support. I would suggest that any such definition would have to include the phrase for the benefit of the child. It's got to be something that a parent is doing for the benefit of the child. I would note that visitation is for the benefit of the child. And in fact, our legislature has so recognized that fact that that's a ground for termination. If you don't visit for 4 months, you can have your rights terminated. Best interest factors in the termination statute, 361113I, one of those factors is visitation.
What was the testimony as to who was paying the $100 a month for the visits?
He was having to pay Solomon Solutions the $100 a month.
He was paying, or the mother paid, or who paid?
This is one where you have a stay-at-home mom. He was the guy working. They were both living together the whole time, but he was paying the $100 a week to Solomon.
Okay.
Wasn't the court's concern about the fact that he couldn't afford to pay Solomon to visit the child, but he could afford to pay $130 a month for Delta 8, Delta 10 CBD?
The trial court in this termination was concerned about that, and he did note that in his order. And I think it's kind of analogous to cigarettes. I mean, Delta 8 is a legal product, but I've seen other cases where they've said of parents, hey, you could afford cigarettes. And the trial court did, in all candor to the court, the trial court did make that observation. But I would ask that...
Didn't find failure to visit, found failure to support.
Correct. The trial court did not find a failure to visit, but he did find the failure to support. And I guess part of, and like I said, I'm not asking you to modify the child support. I know you can't do that. But in this case, when I'm reading the case law on it, it struck me how it's kind of similar, because I can't find a case directly on point either. If you're having to pay to visit, does that count as child support? But there are several cases where a parent's under a no contact order. And so eventually there's a termination. They're alleging failure to visit. The parent raises the willfulness argument and says, hey, I was just obeying the court's order. The case I cited to was Re Lyrical T. And in that case, they reviewed some other cases concerning it, and they said basically, the court looks to see if the parent was aggressively pursuing legal proceedings to reestablish the visitation. And in that case, you had a father, he had a no contact order against him. That no contact order did provide, Dad, you can petition the court to reinstate your visitation. 2 months later, Dad filed a petition to modify his child support, but did not file to modify the visitation. Roughly a year later, Dad did file to modify the visitation, but then Dad did not show up for the court hearing. His attorney withdrew. So by the time this Henry Angela was tried, Dad had been under that order for 3 years. The court looked at those circumstances and says, Dad, you weren't very aggressive in pursuing your legal remedies. In the case at bar, I would suggest that these parents were about as aggressive as they could have been. I mean, that last order goes down on March 30th, and 2 weeks later, they're filing clean hair follicles. Within the next 2 months, they're attempting to mediate. And when that's unsuccessful, they filed their motion to increase visitation. 2 weeks later, the petition to terminate was filed. So in this case, I believe the parents were aggressively trying to get that order modified. And that order, quite frankly, to be honest, it's a key fact in me asking you to consider that $100 as child support for the purposes of this failure to support ground. But at any rate, they did do that. With respect to the persistent conditions ground, the trial court basically in its order framed the issues which led to removal as the parents are unstable, they're unwilling to care for the children. Now, the conditions that were alleged at removal, the petition alleged that the parents were using drugs, the parents won't work, they didn't have a job, the parents had no home, the mother has untreated mental health issues, the mother has legal issues, and then there was some allegations about a prior house fire incident. When we went to court, my client and the mother, quite frankly, had remedied the concern about the drug use. They had filed clean hair follicles. There is nothing in the record to contradict those hair follicles. My father had a job. Now, in all candor, the trial court found that he had had several jobs. He was not the most stable. But at the time of trial, he was working at Loopy's Pizza as a retail type of job, making $11 an hour, and had been there for 4 weeks. The parties had a home. There was proof offered that they had been living in that home for almost a year at the time of trial. There was proof offered that mom was getting counseling for her mental health issues. Mother, at the time of trial, still had outstanding criminal charges for a theft from back at the very beginning of the case. Quite frankly, I don't know if she has since resolved that or not, but at trial, those charges were still pending, but there were no other charges of which we were made aware.
Mr. Crittenden had offered your client a job, I think gave your client a job at one time, didn't he?
He did.
And he lost that job because he was smoking marijuana.
Correct. It was, I think, about a year or so before removal. But there was testimony from one of the petitioners that he had worked and that he had to fire my guy because he was using marijuana.
What about when the children were at the Mr. Wolf's house? I guess that was the uncle? Is that?
What about?
When they were there, the court made fairly significant findings with regard to how the children were cared for during that period, when they said while in mother and father's care, LT would pull out her hair, bang her head on the walls, suffered from anxiety, diaper rash, were not properly fed.
The trial court made several findings, like you're saying, about the inadequacy of the parents' care while the children were residing with Mr. Wolf. That, again, was before the removal as well. Our contention, and it's in my brief, is that at the time of trial, these parents, the conditions which led to removal had not persisted. A large part of what the trial court found was that, yes, Mr. Marble, your client and the mother have lived in this home, but they're having to get a rent subsidy. That rent subsidy is due to end in the next month or so. What are they going to do when the rent subsidy ends? And because of that, he found their living situation, I think he described it, their economic situation is tenuous at best, which when I read that, I thought to myself, wow, that could describe a lot of parents. And a lot of these findings on the conditions are conditions which, like the care or lack thereof while the children were at the Wolf's house, these were conditions which were before removal. Really, the only evidence we had about after removal was to clean drug screens and also the supervision. Solomon's Solutions, they had a person who supervised the vision, and she saw or supervised the visits. She saw the visits, and she said the visits, they're going as well as we would want them to go. We have no concerns about these parents. And so I guess part of my argument, to boil it down, is we're alleging persistent conditions, and we're finding that the conditions have persisted because of what they were before removal. I don't think that's a proper analysis of the ground. We have to find that the conditions have persisted up until trial. And in this case, there were several of the conditions which, quite frankly, just did not persist.
Counsel, you've used your time.
Thank you.
You have your time for rebuttal. Hear from the appellee.
Good morning, Your Honors. Phil Jacobs from the Bradley County Bar for the appellees, the Crittendens, who are the aunt and uncle. Just a little bit of background on the aunt and uncle. They've been married for 13 years. They lived in the same house for 10 years. They had a 9-year-old son. They both are employed, making approximately a combined $100,000. They are the maternal uncle and aunt, and Mr. Wolf is the maternal grandfather. Yes, Your Honor. And what happened in this matter is in October, when these children were less than 3 and about a year, there was a house fire where the mother barely escaped and their home burned, and so they had to go live with the mother's father, Mr. Wolf. It was in that brief period of time that the Crittendens began to interact with these children and were put on alert that there were some real problems, whether it's the being locked in a room, the lack of care, the pulling of the hair, just a lack of just concern for these children. So they were on alert that there was a problem. And as Your Honor just pointed out, they've been involved with this young couple for a while, offering multiple jobs that the father either turned down or quit because of drug use, just trying to get these young people stable. Well, when they get evicted essentially from Mr. Wolf's home because Mrs. Wolf sadly passes away around Christmas of that year, and the mom is charged with theft over $10,000 for stealing things from her own mother. Okay, won't go into what's happened in that case since because it's not in the record, but that's the status of the case. Is they're kicked out of Mr. Wolf's home because Miss Wolf has died. Mom has allegedly stolen all this stuff, but in the record, father says, yes, she told me she stole all the things. So we get to February, and they're living in this hotel. It's cold. My clients are driving by the home trying to figure out what's going on, and left with no other choice. Parents aren't working. They file petition for dependency and neglect. And their plan is to hopefully get the parents back up on their feet and hopefully work some type of reunification plan. They have to take the children immediately to the hospital to address emergent medical issues that the children are having. And then you get into these successive orders where it is clear that the Crittendens want to reunify the children with their parents. First, they're offering to supervise. That doesn't work very well because there's some personality issues. Then the parents volunteer to go to Solomon Family Solutions. Well, that doesn't seem like it's going to work logistically. So we say, all right, well, you can just try to visit. We'll make them short, just try to visit. Well, that doesn't go very well, so we're immediately back to Solomon Family Solutions. And yes, they visit and pay to visit, but the record is clear that they miss twice as many as they ever make in those months of April, May, and June. Okay, there's some, director came in and testified about how many they missed. There was some dispute about how many they went to or didn't go to, but then they just quit going. And then they tried to get back and they didn't pay, and so they just quit going altogether. So that's kind of the background, but certainly it was the intent of my clients as family members to try to reunify. And when that became just not in the children's best interest, in their opinion, we filed a petition to terminate. And what's important is the legal standard here, because what the burden of the petitioners was and is to show clear and convincing evidence that mom and dad did not pay in that look-back period of time. And for dad, he admitted, I didn't pay any support during the look-back period of time. Mom says she paid 2 payments of $100. She had no proof of that. My clients disputed that. The court did not find favorably on that issue to the mom, and even if he had, finding was it was not more than a token. So once that happens, the burden shifts then to the respondents to prove that their failure to support was not willful. And the court found that they did not do that, and because they had so many resources available to them. They were receiving both of the children's COVID-19 relief, $600 a month. They were receiving both their own COVID relief, which was, I think, $200 times 2. They were receiving over $400 in food stamps. They were receiving this voucher for their home through, I think, the United Way. Mr. Truelove was working, making $1,300, $1,500. So they had almost $3,000 of income, plus they had the voucher. So the court said, yes, they had the ability to pay and chose not to pay.
Counsel, what about what's your response to the opposing counsel's argument here that, look, they were having to pay $20 an hour to visit the children,
Well,
and that ought to count towards some kind of support or something?
Well, let me start with this. They hired a private attorney, so they had resources to do that, and then they voluntarily agreed on 2 different occasions to do the Solomon Family Solution. So they were given opportunities to do it otherwise, and they voluntarily did it. So they were representing essentially that we could afford to do this, and then did not do it. I've never seen support that did not go to the direct benefit of a child in terms of diapers, food, clothing, shelter. And I think child support is defined in the guidelines as to things that meet, that make up what it takes to care for a child. Paying to visit your child is not supporting your child, so I would discount that. Be that as it may, they visited 21 times, $20 an hour, I don't know, you can do the math. It's not a very substantial amount of money, and they just quit doing that. So I don't think that argument has any merit, but I'll leave that up to your honors to discretion. Going into the second ground, which Judge Jenny did not find favorably to the petitioners, but is relevant to the best interest analysis, is that failure to visit and how involved they were or not. And they just quit visiting in July, and August, and September, and October, and then 2 visits in November, and then stopped in December and January, and then hadn't visited, thereafter. So there was no contact for this 6-month period of time. And we will get to those factors in just a second of, were these parents visiting, and were they, involved in these children's lives, or did they have an attachment? All the proof is in favor of no, but it did not rise to the level, in Judge Jenny's opinion, to terminating their rights. With reference to persistent conditions, what the underlining idea is, okay, Judge Jenny, in April had said, deny the petition, I'm going to put these children back with the parents. Would they be dependent and neglected in that moment? And is that the same dependency and neglect that existed at the time of removal? And overwhelmingly, Judge Jenny found it was. He laid out specifically what his concerns were and what they have been pled and acknowledged in February 21, which is housing instability, employment instability, mental health, underaddressed mental health issues, unresolved criminal issues, just the inability, as he, the trier of fact, observed these parents, just had the inability to understand what it would take to care for these children, and the fact that they were not properly cared for, their needs were not properly met. And as Judge Jenny tried this case, and he made in his 37-page opinion specific findings about just their inability to meet the needs of these children. So what Judge Jenny found is clear and convincing evidence was, if these children were returned to the parents after 6 months of removal, they would still be dependent and neglected. The court, what the court did in this case is tried it over 2 days, left the proof open for all parties to prevent findings of facts and conclusions of law, and then allowed Ms. Love to do that, respond to that as the guardian ad litem, and then closed the proof. He then took the proof and all of those findings of fact, and he made a detailed A through T factor by factor analysis of what was in the children's best interest. And as it's pointed out, not all factors are applicable, not all factors are weighed the same. The court doesn't, the petitioners don't have to carry the burden of proof on every single factor, but overwhelmingly in the totality of it, in Judge Jenny's opinion, was that clear and convincing evidence existed that it was in the best interest to terminate the parental rights of these parents. Parents were not stable, and the children had found stability in the home of their uncle and aunt. The children at the time of removal were 4 months old and 14 months old, respectively, and now it had been 13 months. So 3 times the youngest one's life in almost equal amount of time. The oldest child had been out of the parents' home. When you compared the petitioner's ability to meet the needs versus the respondent's ability to meet the needs, the respondents were just found extremely lacking in what they had done, as Your Honor previously pointed out, while in the home of the Wolves and beyond, to meet the needs of these children. They were neglecting their children. The parental attachment had reached a level where the children were now completely attached, not only to the Crittendens as the parental figures, but also their 9-year-old son and this kind of larger family that Mr. Wolf represented. Again, to the point I brought up earlier, or highlighted earlier, the lack of visitation, 42 canceled visits or unkept visits, and then just the months and months with no contact, either calling the Crittendens to set up visits or calling them to check on the children. Just parent could care less or could have cared less about these children. Court highlighted the fear factor. Yes, these are very young children, but the oldest child was picking at her hair and picking bald spots at her hair, showing signs of anxiety, a problem that was curbed or cured upon placement with the Crittendens. The parents had made no lasting adjustment, and yes, the United Way qualified them for this 725, but Judge Jenny was concerned that had lapsed, and the proof was that the parents had no plan. And despite all the government subsidies, state and federal, at their available to them, they had not been able to pay support. They had not been able to visit. They had not saved any money. They had no real path forward that anybody could rely on as stable. So there was no adjustment. The mom had voluntarily quit her job and was not caring for any children. And you could call her stay-at-home mom, but she wasn't caring for anybody. And then she was still facing these significant criminal charges. Again, factor R, the home was not stable. And again, failure to provide support is factor S. And again, Judge Jenny eloquently details, as he tried the case, his concerns for the parents' just inability, called it lack of maturity, he called it lack of parental fitness, lack of understanding of the developmental needs of these children, just from viewing them and from their own testimony, that they wholly lacked the ability to care for these children, and therefore it was not in the best interest of the children to place them back in their home, and certainly was in the best interest to terminate their rights. He made careful consideration of the mom's mental health issues and essentially the parents' emotional inability to have the children back in the home. So, this was never the Crittendens' intent. I can vividly remember a phone call I had with their counsel saying, this is family. We want to see these children back with your clients, the mother and father. Well, that quickly deteriorated into a situation where it was no longer tenable. It was never going to be safe. Children were going to be in danger, and my clients, being stable, loving people, knowing the situation intimately, did what they thought was best, and they filed this petition. And after very skilled lawyers defended the rights of these parents, and a very seasoned guardian ad litem heard all the proof, and 9 individuals testified, the court found not 1 but 2 grounds by clear and convincing evidence the termination should occur. The court did a detailed analysis following the law literally to the letter A through T, and then applying all the factors, and found clear and convincing evidence exists to terminate the parents' rights. This is the best home for these children. It is a family placement with a sibling, essentially now a 9-year-old older brother, and this is what is best. And so we ask the court to affirm Judge Jenny's opinion. I've got some time. I don't hear any questions, but
I hear none. Hear from the appellant rebuttal. Counsel, I don't believe you reserved any time, but we'll give you just very brief, about a minute or so.
We don't dispute that back in February of 2021, they removed custody. If you notice in my brief, and I think also in Mom's brief, we're not arguing that they got that wrong. Our parents needed some help at that point. They were dependency and neglect. We're also not asking the court to return these children to my client or to the mother today. And in fact, if you were to deny the petition to terminate, that's not what happens. If you deny the petition to terminate, what happens is the last valid custody order springs back into effect. The last valid custody order that I saw was the one that gave my clients some supervised visitation at Solomon's. Now, my client still has a pending motion to increase that certainly I guess they could get the juvenile court to hear that, but we're not asking this court to return the children to my clients today. We're just simply asking, is it in the children's best interest to go ahead and cut these parents totally out of the children's lives?
All right, thank you, counsel. Appreciate your arguments and your briefs. We're going to take a brief recess here to kind of rearrange some judges. Y'all are certainly excused before we call the next case.
All rise. This court is at a brief recess.